Mr. Speaker, this bill seeks to amend certain acts to give effect to certain recommendations of the Financial Action Task Force to enhance the legal framework for preventing, investigating, and prosecuting offences relating to money laundering and terrorism financing, etc. The recent infamous $3 billion money laundering case has cast a negative spotlight on Singapore. It is therefore important that the right lessons are learnt and applied, and laws and procedures are enhanced to prevent or minimize similar cases in future. Mr. Speaker, I would like to see a clarification in respect of the amendment under Clause 17 of the bill, that is to say Section 372 of the Criminal Procedure Code 2010. In MHA's press release of 2nd July 2024, it was stated at paragraph 16 that, I quote, "Taken together, these amendments will prevent the premature release of seized properties while investigations are ongoing and avoid a situation where an absconded person evades investigations by staying out of Singapore and makes a successful claim to the seized properties because investigations have not been able to proceed." May I ask the Minister whether there has been a recent precedent, such as a recent case or precedent such as from the recent $3 billion money laundering case, or has there ever been any precedent at all where an absconded person evaded investigations by staying out of Singapore and then made a successful claim to the seized properties as investigations had not been able to proceed? Mr. Speaker, in the recent $3 billion money laundering case, we read of mostly Cambodian nationals of Chinese origin setting up residency in Singapore, buying expensive real estate, posh cars, and other types of valuables and properties. We read that, and I quote, "Millions of dollars earned over the years from an illicit gambling ring were turned into luxury cars, extravagant watches, properties in Singapore's most lavish neighborhoods, jewelry, designer goods, cryptocurrency, and cold hard cash." And this is from a media report. So far, we read of media reports of kickbacks received by property agents or bankers taking cuts for property purchases. But the purchase of these properties required various parties or professionals who should be obligated to do AML due diligence checks required by the authorities. The money launderers could have brought monies into Singapore either by cash or by remitting monies to Singapore via their existing bank accounts. Where money was remitted to bank accounts in Singapore, the banks located in Singapore would have had the chance to do their AML due diligence searches. For those who bought real estate here, besides the banks, the real estate agents, as well as the conveyancing lawyers, would have been required to do AML due diligence checks, including, especially on the source of funds they put up for payment. I'd like to ask the government for the banks, lawyers, jewelers, or other persons who help with or handle any of the sales transaction for the different types of properties on behalf of the members of the $3 billion money laundering ring, whether all of them carry out the necessary AML due diligence searches. Did they file any suspicious transactions report? And if so, what were the authorities' responses to such reports? Mr. Speaker, a few years ago, I was among an early group of practitioners who had to complete a prescribed anti-money laundering, counter-financing of terrorism course and an AML CFD proficiency test as part of new requirements by the Accounting and Corporate Regulatory Authority, ACRA, for anyone seeking to register or renew his registration as a registered filing agent of companies. The program aims to ensure that RFAs are well equipped to comply with AML CFD regulations through continuous education. RFAs have to fulfill the new requirements once every 2 years as a precondition of their renewal. I passed the test, but subsequently I did not remain an RFA. However, the course and the test left me with deep impressions. In particular, while strict adherence can be onerous, if all professionals and service providers were to take the AML due diligence checks seriously and conscientiously, one would have thought that they would greatly help to prevent, or at least to minimize, the bringing in or the utilization of funds which are subject to prohibitions under the AML regulations. So far, not much is directly disclosed about AML due diligence efforts of the bankers, property agents, lawyers, or other service providers or sales agents who serve or assisted the convicted members of the $3 billion money laundering, $3 billion money laundering case. Will the government share with this House what are the lessons learned from this case, if any, in respect of the adequacy of the current anti-money laundering due diligence efforts required of the banks, property agents, sellers of precious stones or metals, lawyers and other service providers involved? Mr. Speaker, I look forward to the Minister's clarification. Notwithstanding the clarifications I seek, I support this bill. Thank you.
Order, I propose to take a break now, suspend the sitting, and I will take the chair at 3:50 p.m. Order.